This afternoon, the reason we have this topic is electronic discovery has created new challenges in litigation. And people who have grown up, you young lawyers who have grown up with advancing technology, are in a better position than us old to address the problems. And so consequently, you bring to your law firms and you bring to the practice of law an advantage that we old folks don't have. And so today's panel is going to talk about that. I'm going to introduce the moderator and then we'll hear from the panelists. And I am very honored to introduce today's moderator, Tom Lidbury. Tom has been a founding member and a moving force. He was the key drafter of the Second Circuit Electronic Discovery Pilot Program principles. He has been a leader in the electronic discovery area. He's an accomplished trial lawyer. He has jury verdicts in the multi-millions of dollars. And he is a person who has published and lectured in this area. And so we are very honored to have him as our moderator. There is one other thing I want to mention, and it's just a little advertisement advancing down the road. As you know, or may not know, Seventh Circuit Electronic Discovery Pilot Program is now in its 50th. And we started the program in May of 2009, and along with folks from the Sedona Conference. Ken Withers, who's the executive director in charge of judicial education for the Sedona Conference, came and spoke with us for the first time. Tom has been the chair of the working group on electronic discovery for the Sedona Conference. And the Sedona Conference is putting together a program that is called Cooperation Training. They have did a similar program at Georgetown University Law School. They will be doing a program on February 12th and 13th, right here in Chicago. And so you can just kind of scratch it in. Of course, the 12th is the state holiday. The courts are closed. The state courts are closed. But the 12th and 13th, Sedona Conference Cooperation Training Program. And you'll hear more about it as we go along. But I want to now get out of the way, turn it over to Tom Lidbury and our distinguished panelists. So thank you, Tom.
Thank you, Your Honor, and welcome everyone. Let's get started by introducing our panel. Why don't we start with Jeff? Why don't you just tell us a little bit about your background as a lawyer, where you're at, and what your e-discovery background is.
Sure. Jeff Scherer. I'm with Sidley Austin here. I'm a partner in our litigation practice. I sort of fell into e-discovery in the early 2000s because I started doing it. I worked on one of our first matters that was a hosted online review, and once you do something once, they have a way of coming back to you a second and third and fourth time, and it played to an interest that I've always had in technology. So I've been doing more and more e-discovery over the years. Now the bulk of what I do is in the e-discovery area, and it's now bleeding into areas like information governance and data privacy as well.
Okay, thanks, Jeff. How about Matt?
Matt Bills. I'm a partner at Grippo and Eldon. I'm a commercial litigator and got involved with e-discovery matters several years ago in developing and founding our electronic discovery resource group at the firm, and then I'm also involved in the Seventh Circuit Electronic Discovery Pilot Program.
Mark Rossi?
Yes, Mark Rossi. I'm with Merrill Corporation. We are a financial, corporate, and legal regulatory document company, so a large part of what we do involves the discovery area on the legal side. I'm the business person, the non-lawyer on the panel, and I've been with Merrill for 23 years locally, and I am a member of the education group of the Seventh Circuit Pilot Committee, and we contributed last year a basics or mechanics of e-discovery guide, which will be relevant for today's discussion, I think. Glad to be here.
Thanks, Mark. Tiffany?
Hi, I'm Tiffany Amlott. I'm a senior managing associate at Dentons. And I sort of echo, one of the first projects I got involved with out of law school, there was some concern about electronic information. And being involved in that one case and getting some information, people tend to come back to you. So that's sort of been an interest of mine. I do corporate litigation generally. And I'm an e-discovery mediator in the Seventh Circuit pilot program.
Thanks, Tiffany. Chris Messervy?
I started as an associate at Jenner & Block, and then I moved in-house to Groupon, where I work on various different areas of litigation, from commercial to employment to securities. But I also manage Groupon's e-discovery aspects in all their litigation, and also help develop the policies in place for preservation and collection.
Okay, thanks, Chris. So Jeff, I'm going to start with you. What is e-discovery? How is it different than regular discovery, and why does it matter?
So at the very broadest, e-discovery is discovery of electronically stored information. It's I think in getting to a point now where you can drop the E, most discovery is e-discovery these days, as it relates to documents, and you could be dealing with anything from email to your Microsoft Office files, things that you'd have in your My Documents on your computer, databases. Most of our clients have proprietary applications that generate anything that generates digital data, mobile devices, text messages, instant messages. This is all the information that falls under the scope of e-discovery. And how does it differ from regular discovery? As I said, these days, it is most of document discovery, but how does it differ from what I think of as traditional paper-based discovery, the discovery we were doing 15, 20 years ago? There are some very big differences. It differs in volume, certainly. A lot of that has to do with the ease with which electronic information is propagated. Instead of having one copy of a document today, one email sent to 10 people that gets forwarded, and all of a sudden you've got 100 copies of a document in various locations throughout an enterprise. So the volume of the information, the variety, the number of different types of different file formats, different types of data that you have to worry about in any given litigation matter, the variety of the locations where you find your data. You can't go to a file room or even a warehouse and know that you're going to have all of your documents in one place. They're going to be spread throughout an enterprise, and now throughout an enterprise and a lot of employees' mobile devices. I think the other way that it's different, and I think courts are now starting to starting to recognize this more and more, is we're no longer in a world where you can request or even hope to produce all documents related to a topic. Now it's about finding and producing enough documents, what's sufficient, what's proportional. Those are I think those are the most significant differences between digital discovery, e-discovery today, and traditional paper-based discovery. You've also got I think a breadth of ways that you can approach e-discovery in a way that probably wasn't true with paper, where it was pretty straightforward. Pull it all, review it, and produce it. The variety of approaches you can take to executing an e-discovery project, also much broader. And then why does it matter? I think particularly for this audience, e-discovery is something that in most cases, and I see this in my practice at Sidley, often the responsibility for coming up with an e-discovery plan tends to fall to our associates. It tends to often to fall to our junior associates. It's something that, as Judge Holderman mentioned, our younger attorneys in most cases know more about the technology that's generating the information than a lot of our partners do, frankly, than they know more than, some partners, care to know. So there are opportunities there for associates to really take and run with an important part of the case. And particularly in some of the areas now where you get into the technology-assisted review tools, things that allow us to deliver some very nice results in ways that leverage technology. These are things that the associate understands them and can take them to a partner, maybe take them to a client that hasn't used the approach before. If you're the person who's come up with the idea, and it turns out you get a great result and you save a lot of money, there's a lot of upside there for associates to, who can do that. So why does it matter? It matters for a lot of reasons, but I think for this audience, I'd say most significantly, it presents a lot of opportunities.
Okay, thanks. So Tiffany, how can an associate leverage e-discovery into the glory of full utilization and partnership?
To kind of echo what Jeff was just saying, I think this is an arena where, you can position yourself as a mid-level associate to have partners calling you for advice on something. I have found that a lot of partners might not be interested in learning the details of e-discovery, and they rely on others to do that. If you're one of the people that steps up and wants to learn more and becomes a reliable source of that information, in essence, you're making yourself more valuable to your organization. So whatever you can do to make yourself more valuable to the organization, I think helps your career generally. So if you can kind of grasp this niche and be the person that the organization relies on or turns to, even in part for some of these areas, I think that's a good thing to have. I think it's also an arena that a lot of people are afraid of. And I find that with regardless of age. So if you're a person that kind of steps up and says, can you explain this to me? I want to be on the call with the vendor or the IT person about, the client's server systems and how we're going to collect this. That's a unique situation to have someone show that initiative and interest in this area. So I think that it's an area that holds a lot of opportunity, and it's not perhaps the area that everybody gathers around in the law firm and tries to grasp these opportunities. You're generally not jumping over somebody else who wants to get involved in this. But just on a realistic level, again, as Jeff said, this is applicable to every single case that comes in the door now. So it's not going away. It's just going to be a part of your practice. The more proficient you are generally in your practice, the more valuable you are to your organization, and that enhances you within the organization in your career as well.
And adding to that, from the client's point of view, you may not think the client cares about associates, but it does. And so if we can see an associate who came in and saved us money or came up with a unique idea, it's more likely that we will like to have them on future cases. So you got to think of it, not only are you building a relationship with the partners, but also with clients. And if you can really get some face time or just do something that the client recognizes and it makes a difference or saves them some money or helps streamline something, it's a big win for you.
Mark, you're the technology side of the house here. Tell us what people need to know about technology that's out there.
Well, a stat that I wanted to put out there was that the technology part of e-discovery, which is basically the software-assisted part, the current statistic on that is that it's a $1.7 billion market now, and in the next 5 years, it's pegged to be a $2.9 billion market, so that's 15% compounded growth over 5 years in the technology software part of e-discovery, as opposed to just kind of a basic service model that's not software assisted. So I think the good news for the younger people in the room is that you haven't missed much, because most of the technology has been developed the last 3 years that's really reinventing the efficiency of discovery. So It's not that daunting of a task because most of the people that are younger are very good with technology. It's second nature, and most of those technologies have been available and are being refined right now. So, and that's kind of somewhat similar when Jeff said you can't possibly, even though there's been efficiencies, you can't possibly handle all the data that's available because now we're also entering that age of big data, and so a topic that maybe wasn't as interesting just to everybody is now more interesting because it's wrapped under that whole big data area, so it's getting a lot of notoriety now. Basically, attorneys, corporate, inside legal, judges, anybody involved realizes that technology is really the only way to move forward here. So you're in a great position because I think most of the people in this room are very comfortable on the technical end, and you haven't really missed a lot. Again, there's many opportunities to both self-tutorial opportunities, and also a lot of the really game-changing stuff has been recent.
Jeff, you look like you wanted to say something.
Well, I was just going to say, to pick up on what Chris and what Mark said is, and tying back to the differences here, with the volume, the variety, I mean, the differences between paper and electronic discovery come in a lot of cases, if you don't do it smart and you don't do it right, very high cost, very high risk. Then there are a lot of ways that e-discovery can go off the rails, and to do a traditional review where you look at everything you collect for even a small volume of data, it gets to be an extremely expensive undertaking. So the opportunity here is to take the types of technology that we're talking about and deliver for the client what can be a home run, in that you're reducing risk and you're saving money. You're usually getting it done faster, and you're often getting it done better. So that's...
Okay, this leads me in perfectly to this. Chris, do you buy that? Are you sold on the idea of using this fancy, expensive technology?
You can be, and so when you come to the client and you propose it, the first question I'm going to ask, or one of the first questions I'll ask, why? And the worst answer to give is because it's the new thing, everyone's doing it, because it matters to the client, it matters on the situation, it matters on the case. So you need to think about why, in this case, for this set of discovery requests or for this issue, this tool is the best. And the reasons listed, like reduce risk, faster, better, lower cost, are all great. And if it truly is the case, but you can't just say it's lower cost, it's faster, have it thought out and explain why it's faster than option A, option B, option C, and explain in detail why it's faster. Don't just give platitudes or open conclusory statements saying it is faster, because I've gone to many pitches by various vendors saying how their e-discovery process is always best and always most efficient. And you have to really break it down and say, in this case, this is why it's better. In this case, it's not better. And when you do that, also advise the client. Don't just say option A, option B, option C, and leave it up to the client to decide. We really want you to say, here's your options, but I think option B is the best for these reasons. And I think that'll win over the client much more than just some platitudes or just listing options.
Certainly, it depends on what you're trying to accomplish. You can really over-engineer the technology portion depending on what you're trying to do. So I agree with everything you said.
And Mark, we'll get into more of this in some more detail later, but why don't you give us an overview of what those technology options are? What's what would be over-engineering? What would be middle ground? What are the options that are available to people?
The basics there would be, what are the damage, what's the cost factor? I mean, you can't employ, even though the technology is a lot more efficient, you can't employ technology at a cost that the case is too small, or that it's not that complex. I mean, the data is readily available. Or you're working with a corporation that is more advanced on the e-discovery end, so they have internal practices that put them in a position where you're not grabbing data from everywhere it's not their first rodeo. I mean, they have a definable process, and so the amount of data is manageable. So all those things, that kind of strategy of what we're trying to accomplish and what we're starting with, and that's all very important. You just don't, it's different every time. It's very, very, very variable. So, and a good, provider or vendor will have access to internal consultants, outside consultants that don't work for the company, internal technology, recommendations on outside technology if there's things that are better for what you're dealing with, because it's all about, a relationship. It's not a company using just what you have, because that's not always the best choice, depending on what you're trying to achieve, so.
So it depends. Are you sure you're not a lawyer? Matt, most of us went into law school so we didn't have to learn technical stuff. So now that we realize that's unavoidable, where do we go to learn about this stuff?
Yeah, the good thing with the e-discovery area is that there is a wealth of knowledge that's really pretty easily and readily available. We actually tried to put together some of the key resources for everyone and have given them to you. And those are great starting points. But there are a number of websites and groups that compile various information, both on the legal side, the rule-based, the development of the law side, and also the technical side. A couple that I thought are worth highlighting are the Sedona Conference. If you're not familiar with the Sedona Conference, and Judge Holderman mentioned that at the beginning, it's really, if not the preeminent think tank in the e-discovery area, right up there. And it produced a number of white papers and various tutorials on the entire spectrum of e-discovery. Again, from the more legal side and what the courts are doing to the technical side as well. And their website has just a wealth of knowledge. And the other one is really a more local plug, but I think as good as anywhere, and that's the Discovery Pilot program website, discoverypilot.com. We have there with Seventh Circuit Pilot Program website a link to resources, a compilation of, again, some of the best resources. And then also, in addition to the pilot program principles, which may be in effect in your particular case, if you're in a case where the judge has implemented those as part of a standing order, but certainly they are good guidance. They have been cited and used in a number of cases. And then also there are a couple of model orders that have recently been promulgated that are great starting points in negotiating for in a 26F conference, for example. And I know some of the other things that we're going to talk about, including alternative privilege logging, 502D orders. Again, good. There are a lot of good templates, places to start. And again, like anything else, where you've got a template, you've got to customize it for your particular case and think through various issues. But rest assured, there are plenty of resources, so you don't have to be starting really any of this stuff from scratch.
And Mark, what are technology companies like yours doing to educate the legal community?
Well, first of all, like one of the things that goes on at our office, which is in the Loop, there's various lunch and learns. So there is a e-discovery related topic once a month, 12 o'clock to 1 o'clock, usually available for CLE credit, that covers some area of emerging technology or emerging efficiencies in the e-discovery process. That's one thing. There are other webinars and CLEs put on as well. There's connections to what's out there. Illinois is actually was a kind of a pioneer in the e-discovery area. Now with the Seventh Circuit and the work that's been done through Judge Holderman's guidance, we continue to kind of be a pioneer. So there's just more and more information available that a provider, vendor can direct people to. And then anyone that's interested in technology, I think myself or any other provider in this space would, is always available to demo anything new and introduce them to partners technology partners that we're looking at as well. So again, there's Chicago and Illinois, there's lots and lots of resources available.
Okay, and apart from the technology that's available to process all this stuff, Chris, what does an associate need to know? What do you want to see them know and asking about your internal systems, your IT technology, your process? What should associates be thinking about and asking about?
There's two things to know just generally. You need to know about the company, and you need to know of the importance of that case to the company. So with regard to the company, don't assume they're going to have the same email platform that you've worked with forever, or they're going to store documents in the same way. With so many cloud-based systems out there, documents are going to be in the cloud. There's going to be emails in different forms. People are going to have different types of computers, and data is going to be all over. And you need to make sure you either try to find that out from a partner who already knows that information, or if you can encourage the partner to get on the phone with the client early on, map out all the potential areas that could be discoverable in this case. And once you know that, you can get a good idea of what needs to be preserved, what needs to be collected, and get a strategy for the case going forward. But also, outside of the company, focusing on the specific case at hand, how important is this case to the client? Don't think that every case is important, but some go to the core of the business, some are just lower end and they don't want to spend a lot of money and there's not much risk. So take that into account. You don't want to go after each case and try and do over-the-top discovery when a really simple solution might work for this case. So keep it tailored to the specifics of the case, and then also get a good understanding of just a layout of how that company keeps documents or data that relates to the case at hand.
And Jeff, if someone wants to get involved in e-discovery, but they're not a guru on it yet, how can they get plugged into the process?
Sure. There's I think two aspects to that. One is how do you become a guru, or how do you become more educated, more informed? And Matt touched on some of the resources that are available. Things like the Sedona Conference. I've been going to Sedona for 8 years now. Excellent programs, excellent written guidance, Seventh Circuit. So you can, for attorneys who are interested in the organizations, get involved. Sedona is $295. Anybody can join, $295 a year, and you're a member of, Working Group 1, and they've got a couple meetings a year. They're excellent events. So there's a lot in terms of the organizations you can get involved in. If you just Google e-discovery vendors, you could probably do a webinar during each lunch hour of your 5-day week with the number of programs that are out there. And many of the vendors will record these webinars, so you can, if you've got particular topics, and they cover everything from technology-assisted review to mobile devices to more information governance oriented. You can find just about any topic, a panel usually presented by knowledgeable attorneys or service providers, accessible online. So there's there are all of those resources to learn more and to get more comfortable in the area. And then when to the question, how do you start doing it?
Yeah, billable work, please.
Billable work. That's a matter then of getting out within your firms, letting people know what you can do, letting people know that you're interested in it. This can be as direct as going to partners that you work with or even that you don't work with and asking for work. Say, hey, I've been spending a lot of time, learning, educating myself in this area. Would love a chance to apply that on one of your matters. So if the opportunity is there, please let me know. There are, you can do what I think of as sort of coffee or calls. Stopping by to talk to people, not necessarily on a particular matter. But here are some of the things that I've learned that I'm seeing. Here are some things that we might be able to do for our clients. Have you thought about this? And if you get a matter that comes along that would be a good fit, you'll let me know, and I'd love to help. At Sidley, I do a lot of internal CLEs for our different litigation practice areas. That's a great, for me, has been a great way to get in front of our litigation attorneys, and they can see that I know this stuff, and I'm giving them something useful, and usually giving them an hour of CLE credit, which is also usually appreciated, so that's another opportunity. It's, it all comes down to sort of getting out there within your firm and letting people know that this is something that you can do, that you're interested in, and that you'd like to work in.
All right.
I'll jump in on that. There is room for that. We all do e-discovery, so we focus on it. There's many lawyers at your firms who don't focus on it, and they'll get a case and they'll just start running it like a case, and they move on and just don't address the issues when they should. So there is a lot of room for you to do this. It's just sometimes you have to change the mindset of some partners or people who traditionally don't worry about e-discovery issues till the discovery phase. So that, I don't know the best way to go about changing the mindset. Maybe someone can speak to that. But there is room on many cases for someone to chime in on e-discovery where it's usually forgotten.
Can you elaborate on what people are missing? Because I think that would be interesting to folks.
Well, they're just not, they don't focus on, they get the case, like, okay, we got to answer, motion to dismiss, focus on that, and they don't talk about the early issues about e-discovery, like what do we need to collect, what do we need to preserve, the litigation hold. That's kind of sometimes pushed to the back burner because they're focused on the core of the case, which is important, but you need to address these issues, and if an associate can get in there and help push those along, it's a great thing.
And I think that that is a good opportunity, and it's as easy, I've found, as, you know, again, you may be working with a partner who does not have an e-discovery focus, and just asking, you know, should I draft a litigation hold? Have we talked, you know, should we set up an interview with the client to discuss how they store information so we can make sure everything is preserved? If you just ask them those questions, almost always, I will say the answers are like, oh yeah, of course, it's a great idea. Go right ahead. And it kind of fronts those issues in a very, I think it's an easy opening. If you just ask those questions, the opportunity is there.
And Tiffany, talk to us about how e-discovery has changed while you've been practicing it, and how you keep up with the moving bar of technology, which keeps advancing.
So I started practicing in 2004. So I got involved in an e-discovery issue pretty early. So I would say my frame of reference is about 10 years. And my disclaimer is I have no technology background at all. My undergraduate degree is in sociocultural anthropology. I profess no science or computer background. And I think that I initially got involved because I wasn't afraid to ask questions. I think it's fine, and maybe I'm wrong, but when I graduated from law school, there was no presumption that you would know how email is stored on a client's servers, or where those servers would be, or how these things are bundled together. And if you're asking, like, what's a PST, I think that's a perfectly fine question. You know, there are these kind of very basic technological details that you need to get your arms around to start assessing collection and preservation, and just not being afraid to ask people to explain that goes a long way. And I think that that's how, you know, as technology keeps evolving, I have to keep asking those questions. I mean, I get new things, as Chris mentioned, you know, clients are storing information in new ways all the time. And you just have to not be afraid and ask can you explain that to me? Okay, do I have this right? You really need to make sure that you understand that. And on the technology portion as well, and following up on the vendor side, when I first started practicing, I took vendors, once you kind of are a point person of e-discovery, vendors will call you and set up, you know, can I meet with you for a half an hour and show you my product or this? And I took every one of those calls and meetings. And I would use that opportunity to talk to a vendor to maybe ask some of those questions. I mean, when I first started practicing, nobody knew how email was stored and that kind of thing. But, you know, I could use them as well as a valuable resource. I think throughout these 10 years, clients are much more sophisticated now, and they expect e-discovery as part of your practice. When I first started practicing, things, you know, I couldn't talk to Chris about how they store information. I had to talk to their IT person, who wasn't excited to talk to a lawyer, and was, you know, didn't know why, you know, he had to just.
Busy and grumpy.
Yeah, exactly. Why
And
are
they
you
speak a
asking
different
these
language, don't
questions?
they?
Yes, and that's where you really have to follow, like, explain that again. Okay, now let me make sure I understand, or, you know, and I often still talk to the IT person at a client, but now clients are expecting this as part of their process. A lot of clients have set up processes in place, they've dealt with this before. So a lot of those kind of initial obstacles and hurdles aren't really there anymore. And in a way, I think the process it's going to continue to evolve, but at least everyone acknowledges that the process is there. Which I think is
The IT people still don't like it that much, though.
I think a great point you made is that if you don't understand something, ask, because first of all, very few people are experts in this area, and if you were, it's changed enough that you're not anymore. So the expectation is just, yes, you have to ask questions, and it's all about, trying to come up with the most efficient way to do things, and you want to be speaking the same language as your client, and if you're not, then you call in a resource in your firm, and if that doesn't work, you call in a resource externally, a provider, and, everyone has to be open to that. You can't kind of fake your way through, because the
Yeah.
end result won't be good. And-
Yeah, this is not
Right.
an area that you can
Right.
fake your way through and pretend that you understand where the stuff is, because you're going to have to make decisions about how to get it. And
Exactly.
you need to understand the basic kind of building blocks.
Okay, Jeff, Chris talked a little bit about preserving evidence and the thought process that starts out in the beginning of the case. What is the difference between preserving evidence and collecting it, or is there a difference?
Preservation, you're concerned with making sure that you lock down your documents and your data in the form that they exist at the time your duty is triggered. And sometimes that's the filing of a complaint. It's whenever you get the reasonable anticipation of litigation that triggers that duty. You want to then typically get a written litigation holdout and make sure that you take steps to ensure that when you need to collect the data so that it can be reviewed and produced, it's there and it's in the form that it was at the time your duty was triggered. I shouldn't say most, but many companies, many law firms have for a long time generally preserved very broadly, and so you'll send out a litigation hold to just about anybody who even remotely touched the subject matter of a case. You'll lock down their data very broadly, and then focus on collecting more narrowly. Now, collecting is when you get to the point typically a little bit later in the case, you've figured out who are your key custodians, who are the people that actually have the documents that we are going to want to review and possibly produce. So many companies, many law firms will preserve very broadly and then try to narrow things at collection. I think now some of our clients are finding that there are some very significant costs to over-preserving and are moving that tailoring process, or that narrowing process, even forward to the preservation stage. Fundamentally, the difference is simply between preserving it to make sure that it continues to exist. Collecting is when you're putting it into the pipeline for review and production.
Talk a little bit about the risks of preserving in place and how sometimes collection and preservation may be similar.
The difference between preserving in place and preserving by collecting. With preservation in place, you're typically sending out a litigation hold notice to all of the employees that were involved in whatever the subject matter is of the lawsuit, and you're saying, to the extent that you've got documents that fall into these categories or that are relevant to this transaction, make sure that you preserve those. Don't delete them. Make sure that you've turned off the empty or deleted items upon exit in Outlook, and you rely on the employees then to follow the instructions. Now, the risk that you have there is that somebody gets it wrong, or depending on the type of case that you have, you've always got the risk that somebody intentionally deletes a document that they don't want to fall into discovery. I think that's less common, but it's a risk that's there. You have the risk, a big risk that we see with a lot of our clients arises when you have employees that are leaving the company. If you don't have a process in place to capture hard drives and mail accounts of employees who are on their way out the door, then, and you've relied on that preservation in place, you can very easily lose someone's data because they turn in their laptop, they leave, and IT wipes the laptop. So those are some of the risks of preserving in place. What we do in a lot of cases is we will take, for the custodians, and you usually know at the beginning of your case who your really critical, your really key people are. So for a small group of critical custodians, the people for whom it would be a catastrophe to lose their data, we will go out and collect broadly by imaging a hard drive. I mean, we don't like doing that, but we'll do it if the custodian's important enough. So we'll collect for purposes of preservation from a small group, and then rely on the larger group, the tier 2 custodians to preserve in place.
And the planning process there, very important, because sometimes if you take some extra steps in the beginning, like anything in life, and maybe conduct some custodian interviews and make sure that you've got the right people, then if you've got the right people, that's the data you want, not all the other data. So there's a lot of common sense, but it sounds easy, but it's hard to prepare, and it's hard to take the time to do all the upfront work so that the work down is more logical, because we tend to always be late and always be under a crunch, and the natural thing is just more is better, and we'll figure it out. But if you can do more planning up front, and make sure that everyone's clear what the strategy is and that you're going after the right things, you don't need everything.
That's I think a common theme in a lot of the areas that we'll talk about. E-discovery is an area where you typically, the return on taking the time at the front end to think through your issues and to come up with a plan will more than pay off down the line, because the nature of ESI is that with the passage of time, it's very easy to lose things. It is both preservation, collection, planning your review, taking that time at the front end to plan out a process, document it when you're doing it, because trying to reconstruct it 18 months later is a nightmare. Doing those things that sometimes we feel like we don't have time for, making the time for them will usually pay off.
But I think that's important too, not only to just, I agree wholeheartedly that that's important, but often these decisions are most helpfully made early on in the case when there are all kinds of things going on. You're digging into research, you're interviewing the key custodians, you're looking into the various legal issues, and you as the young associates on the case may be the ones who need to try to be the proponents of this and talk with the partner and the client about thinking about these things and some of the, pushing some of these cost benefits that both Mark and Jeff are talking about. So, maybe, again, as we talked about various opportunities, this may be a place where you can really make a difference both in the short and long term.
Mark, did you have something to add?
Just that you have to make some decisions in the beginning, and just making it clear that that you're not necessarily done. I mean, if figure out that you didn't necessarily make, the perfect decisions, which you never will, or the best decisions, I mean, it's not static. You can kind of, through the process, decide to look at different things, or the whole, I think the term is supplementation. You can go back and look at things and add things and subtract things. So you got to draw a line in the sand, but you can go back and decide that, that you can look at other things. It's not like that's it,
Let's hear from the client's perspective. What do you think about when you think about the risks of self-preservation and the costs of other options? How do you deal with it?
You want it dealt with early, and the cost is one thing to factor in. So if you have data that could be relevant and may need to be preserved, but you don't think, because you know what's on the data, you don't think it's to be relevant for the case, it's good for the client to find out early so they can go to the other side in the early meet and confers and say, we don't want to preserve this data, we don't think there's anything relevant with it, and maybe you're going to have to go to the court to get the court's approval not to preserve, but it's so much better to flag those issues early than waiting till a year into the case and you have this huge backlog of data you want to get rid of, or it's just costly to retain, and now you have to go in front of the judge at the same time you're doing a motion to dismiss or summary judgment or some other discovery issue. So early on, if you can narrow it down to what you have to preserve because it's costly, and maybe flag it in front of the judge or the other side and get them to agree, no, we don't need that, that's a huge benefit. And then at the same time, when it's the risk, we really rely on our counsel advising us, okay, I know you don't want to do X collection because it's expensive and you want to do self-preservation, but it's very risky in this case because he's a key witness or she's a key witness, or this item is very important. So we rely a lot on counsel advising us. Although it's costly in this circumstance, we think it's worth it. But keep in mind that in-house, I'm a cost center. Finance wants to keep our budgets low. So we're going to be pushing back and say, okay, is it really necessary? Are we okay with this risk? So keep that in mind so you don't, lawyers like to minimize risk. Many people go to law school because they're risk averse. So sometimes you have to take a risk because of the cost, and you have to say, is this a risk we're willing to take at this point or not? And just weigh that in and discuss it with the client. And once again, I'm going to go back to this point. Don't just say, you can do this or this. What do you want? Say, I think you should do X because it's better. The client may disagree and go with Y, but I don't want to be told to do A or B because I can think of A or B myself, and I want someone who has done the work and advises me to do A over B, and ultimately then we'll decide. So that I would focus on that.
So Tiffany, Chris has just sent you a multi-billion-dollar antitrust case, and you're supposed to figure out a preservation plan. How do you figure out the scope of what to preserve, and how do you work on that recommendation to him, and how do the Seventh Circuit Pilot Program principles help you with that?
I think that the scope of preservation depends largely on your client and largely on the case. So when you're balancing those risk rewards and what's reasonable, and you're laying out that A or B and why A or B, I mean, first of all, to qualify this is an area that is purely a judgment call. This is not an area black or white, like you've come to the right answer, wrong answer. I mean, down the road, in retrospect, you might feel that way, but this is a judgment call at the time. And you're often having to make these judgment calls when you have a complaint in front of you, and that's about it. So I think, first of all, you need to collect as much information as you can. Talk to the client, talk to maybe some of the key custodians, the key players in the case, assess what kind of case it is. I might take a different preservation outlook if there's a criminal component or if there's a fraud component than I would in another type of case where, I don't expect allegations that my custodian has altered the metadata of her computer. So you kind of have to assess with, like I said, very little information, the complaint, and maybe talk to the client, talk to some of the key people, and put together and figure out how much it'll cost. I mean, some of these things, you'll be surprised sometimes, a more risk-averse action, actually, it's just cheap, so why not do it? On the other hand, something might be wildly expensive, and, the client might decide that that's a risk they're willing to take because it's just not worth the upfront cost. The chance we're going to need that is so slim down the road. I mean, from an outside counsel perspective to the client, one piece of advice I would say is to make sure that you lay out these risks and rewards for the client. Your client might decide that they're willing to take a risk on this, but you want to make sure that you've advised them that there is that risk, and kind of lay out your recommendations. I think to the pilot program principles, when you're working with opposing counsels will vary. Sometimes you may not hear from them on this issue for a long time. sometimes you know, I think less so now, but every once in a while, you still get these wildly inappropriate preservation request letters that come in at the same time as the complaint. And I think that the pilot program principles help because they provide sort of a basis of, you know, relevant, discoverable information. Just because the other side says you have to, you know, we're sending you a notice that you better preserve all of your metadata on everyone's personal computer for the past 10 years into eternity, you know, that doesn't mean that that's your obligation. And you now have, you know, the principles give you some backup to that effect, that, look, let's talk about this, let's be reasonable about this. And it provides a basis to kind of foster those discussions with opposing counsel to the extent opposing counsel is on this issue before you are. And that just varies with the case.
Okay. Matt, so the time to collect has come. Discovery's ongoing. You got a document request in front of you. How do you decide what to collect?
Yeah, I think it's important to remember and think about where you are in the discovery process. And so really collection could come up in a lot of different ways, but often two different times or two different ways. One may be to collect to figure out your case. What are your defenses? Typically, we're talking here as a defendant. What do we need to collect to understand the case, to figure out what our answer is going to be, or what our legal maneuver is going to be early on. So that's going to be guided by your discussions with clients, your fact interviews, and so you may then do targeted collections from various custodians to figure out and get your arms around the case. And I think though where your question goes is how do you know what to collect to respond to formal discovery requests? You get your 150 broad discovery requests, all documents relevant to anything under the sun. What do you collect? How do you decide what to do with that? I think there's a number of things to do to come up with a collection that is defensible and is reasonable and also proportionate. And so, I think hopefully you've had a 26F conference, certainly should have had one before the discovery was propounded. And so hopefully, and as the rules provide, you've talked about the scope of discovery. Maybe you've talked about collection, how you'll do collection, whether you're going to use search terms, what kind of technology you're going to use as part of even the collection process. So I think in an ideal world, that is part of the cooperation obligation that we have and that we're seeing courts really focus on even more. There are also arguments under the rules you can make under Rule 26 with respect to the proportionality of what's being requested and what you need to collect and produce. And ultimately, you may have to tee this up with the court. But I think the key is to raise these issues early, both in cooperation, negotiation with opposing counsel, and raising it with the court. But as far as then sort of what do you collect and when, once you've either reached agreement or you've got court order, or you've decided this is what's going to be defensible, you look at the key custodians. As you talk about data that may not be held by custodians, you may look to things like search terms. And again, a lot of it's going to depend on the client and the client's systems. So it's hard to say specifically, but really you want to make sure that you've got a defensible, reasonable collection process and protocol in place that you feel comfortable standing up defending because it's been agreed to, the court's endorsed it, you're otherwise willing to defend it.
Let me open this up to everyone on the panel to sort of elaborate on something in there. How often are you getting agreements up front with your opposing party about the scope of what you're going to preserve and collect, what keywords you're going to use or what technology you're going to use, and how many times are you just going in, doing it your own way and dealing with whatever disputes come up as they come up?
I think unfortunately it's still the latter. I think there are, I've seen recently cases that are moving to more of a cooperative early negotiation on things like search terms. Quite frankly, I think the cases move a lot better when you do that and have those upfront conversations. But I still think that's, at least in my experience, that's more of the exception than the norm.
Same, everyone?
Yeah, I think it depends again on the type of case. I think that sometimes when there's sort of a repeat litigation that your organization encounters a lot and e-discovery will be an issue, then maybe, and the client is on board, we've been maybe more aggressive in seeking an e-discovery protocol with opposing counsel right away to avoid briefing and going back and doing it over down the road. So I've seen it success. We do regularly do e-discovery protocols with the other side, but in, a certain client in a certain section of cases.
I think it's probably still the minority, and it shouldn't be. I mean, from my perspective, or the provider perspective, when we get called in for like an advisory function where the people are interested in, trying to do things the most efficient way, that work and those invoices tend to be lower than the average, where, so that tells me something.
Okay.
I do think it depends also on the counsel that you have on the other side and their comfort level and their willingness to engage. I mean, I'll say that I can't think of a case that I've been brought into in the last 3, 4, 5 years where we haven't at least attempted to get agreement on some basic parameters for e-discovery, and usually try to have those entered as an order, usually at the same time as we're getting a 502D order entered. But that's where you're dealing with counsel on the other side that's at least somewhat sophisticated and willing to engage in those discussions.
So Mark, walk us through the electronic discovery reference model from left to right and tell us whether it's a linear thing or whether it's just more of a guide.
Actually, I had a great graphic, but I didn't bring it, so I had to carry it here. EDRM, electronic discovery reference model, basically from left to right, identification, preservation, collection, processing, review, analysis, and production. So that's kind of the original model, and the left side is more about volume, and the right side is more about relevance. So the original model has a larger proportion on the volume side, smaller on the reference side, because you're trying to obviously work your way down. So that model was a very good start to understanding how things work, and very good tutorial for anybody to grasp, and has been referenced countless times over the years in discovery. I think the changes that are happening on that model that people are recognizing is, first of all, if you're talking about cost, which is always on everybody's mind, certainly the client's minds, that the right side, the review side, the relevant side, that's where 80% of your costs are. It's all on the back side. So the better job you do on the front side, then the less money you're going to spend on the backside. So really, I've seen models now that just show if it's a cost model, then it's, review is this big and everything else is very small, because that's where kind of the money is. And so all these discussions we're having, and Matt teed me up very well about getting to a point where you're reviewing the right documents and not too many, and I mean, that's kind of what it's all about. Another thing, which is the technology piece, the technology that's become available over the last few years has really kind of shaken the model up, because the whole, first you identify, then you preserve, then you collect, then you process, then you review, then you analyze. That, with the technology that's available now, that's not necessarily the path anymore. Some of the first technology that came out was ECA, early case assessment, early data assessment is probably a better word. And so if you're performing, if you're using software on the very front end, if you're putting it on your client's server, then are you really doing some of the back end functions in the beginning? Are you doing some form of a review or culling or whatever in the beginning of the process? So I guess what technology has realized is that even though I think the legal profession looks at things case by case, and that basically every case is different, once you decide what you want to do, that process of once you decide what's best to do in a case, that process is repeatable. And you can use technology to be very efficient around that, and it might turn this model upside down the way that you want to do things. Like Matt mentioned, that sometimes doing some, right in the beginning, doing some review right in the beginning, completely different testing, some samples, that's turning the model completely upside down. So technology will warrant probably a new EDRM model. We'll probably be looking at a new one soon that's widely accepted. And
Just picking up on that, not only does it get you, in many cases, doing that early data assessment, what we'll do is go out and take maybe two or three custodians and collect their data and put it into a tool that allows a sort of a look under the hood. Not only does it often get you to a better place in your e-discovery plan, it also, in most of the cases where we do it, gives us a ton of information a lot earlier about the merits of our case and the facts of the case, and that can then affect your case strategy beyond just how you approach discovery. So there's value to that for a lot of reasons.
Chris, how do you look at all this from a budget perspective?
You want to make sure that you don't do too much for a case, so it's all proportional to the size of the case, the importance, and that's an issue with the other side too, requesting too much depending on the size of the case. So you want to keep that in mind. And one thing I've talked a lot about budget because I'm on the in-house side, but you don't want to limit it too much or think, oh, we're going to fight this and they're not going to get it and we're going to save the client some money, when in reality you think they're going to end up getting these documents, or we really need to be broader. So don't go so hard on the budget that you end up coming back to redo it later, so it ends up costing you more. So yes, keep in mind the budget and balance that against what you need to find out early, what do you really have to collect, and what are you going to object on or withhold because you have a good basis or you don't think it's relevant. But don't ignore the fact that if the other side really wants it, or they're going to do a motion to compel, and you're going to have to go back and do it again, just keep that in mind and keep the client informed. And you may end up collecting more than you think you're going to produce, but you think there's a good risk that you would have had to collect it. So sometimes you're going to collect more than you eventually want to produce, and that can be okay if there's that risk that they were going to do a motion to compel and you already have it ready, and going back to do it again would be more costly. So you have to balance that.
And Jeff, when you go see the judge, how do you talk about budget with the judge, and what do you hear back from them?
Typically, if you're talking to the judge about this, it's because you're in a dispute with the other side about whether you need to preserve something, whether you need to collect something, and there's one side's claiming it's unduly burdensome, and the other side's saying no, but it's really important. So the budget comes in there because you need to be able to tell the judge, this is what they're asking for, this is what it's going to cost us to do it, and to be able to put real numbers on it and to be able to support those numbers with affidavits. It hasn't been enough for a long time to go in and simply say, well, this will be a lot of work. So if you've got if you're able to go in and tell the judge in very detailed fashion, this is what we estimate this is going to cost, and you've got support for that, you're going to do a lot better than you would the other way, going in and just saying, oh, it's a lot of work. So you just need to be prepared to have that discussion and to have it in some detail.
And I would, just to build on that too, I think that sometimes this is also an opportunity to build some rapport with your judge. I mean, if you are presenting a reasonable point of view, and you're kind of picking and choosing your battles wisely, you can build a reputation with the judge as the reasonable party. Look, we've done this, here's why. And you can become the party that the judge sort of turns to for, a reasonable assessment of the situation. You can build a bit of trust in that relationship, which I think is always good, and it's good for the case down the road as well. To pick and choose your battles widely and come in there with a reasonable position that you can justify.
These decisions are almost always going to be entrusted to the sound discretion of the judge. And so if you've got that credibility that you've built up by being prepared and by being realistic, you're going to do a lot better in those discretionary calls.
Okay, so Matt, a custodial interview sounds like something that happens in jail, but what is it and how does it work?
Well, I think of really two types of interviews that you want to be thinking about early on, both from a preservation standpoint and from a collection standpoint. One type of interview and understanding you want to gain early is with the client's IT infrastructure. So often you want to talk with someone in the IT department. If the company has sort of a more sophisticated client that has this information available, you may be able to talk with someone like Chris who's got the information about, you know, what type of servers do you have, you know, how often is email backed up and when are backup tapes overwritten and that sort of thing. But you want to get a sense of the IT infrastructure. But you also want to talk with individual custodians who may have relevant data. And this is really, again, circling back to our theme of opportunities for young associates. This is often a point where young associates are the ones out with the client, either in person or on the phone, talking to custodians about what they do with their data. You know, where do you store your email? Do you archive your email? What kind of other relevant documents do you have? Where do you store those? And you often, you know, those are things that you want to do early on. And you know, one of the things to remember is often you are talking to someone who has really no idea what you're talking about. You know, we use things like ESI, we use terms like documents, data. Those mean a lot of different things, and can mean a lot of different things. And so you really have to be very careful and think about who you're talking to, why you're talking with them. Sometimes these may be people that were right in the middle of the lawsuit or the dispute, whatever is at issue. So you may have particular sensitivities as well. So one of the things you might want to do is come up with a template to use for these collections and think about the various things you want to ask about, so you don't miss. You don't miss things. You're not using terms like, you know, document without explaining that might mean an email. What do you do with voicemail, text messages, instant messaging, social media? Those are the types of questions that you're going to want to ask each and every custodian.
To follow up on that, I would say the best plan, the nirvana, is to have a corporation, or to encourage, for the attorneys to encourage the corporations they work with to have a documented process. Because even if your process isn't the best, if it's documented that this is what we do, you actually have a plan, then you documented it, you followed it, and that's key, because you shouldn't be starting from the beginning. When there's a suit, that stuff should be done ahead of time. Of course, e-discovery is not a fun thing that people think about all the time. They're trying to run their businesses, so you know, where does that live, to take the time to have a documented process, have an e-discovery plan? It'd be great if you walked in and they handed it to you and said, this is our process, this is what we do. That, you know, then you're halfway there, but you don't find that very often.
And going back to Matt's point, you have to, I would use like the funneling deposition technique with the witness, because the client, because nicer than in the deposition, but you need to follow up and make sure they understand that includes drafts, notes, everything, because often they just assume you want one thing and they may just say, oh, yeah, here's what you need, and send it to you, but really they have all these files elsewhere. So really drill down on it, and to emphasize, make sure to do this step. You're gonna meet with clients and gather facts. I've seen too many times they meet with a client and then we're discussing collection of documents, and I'll ask, where do they store the documents? And those questions never came up when they met. So this does not go to the core of the issue of the case, and so sometimes lawyers glaze over those, but you have to get those questions in your outline, beginning and make sure you have time reserved to ask, so we don't have to go back to that individual and ask them again after the fact interview. So just make sure that's in there, even though it's not the core of whether or not there was a breach of contract or whatever it may be.
And obviously, there's many, it's multi-dimensional now where information is because of obvious social media. I mean, there's information everywhere, so it's not linear.
I think that's right. Just along those lines, we're talking about electronic discovery, and almost all discovery now is in electronic form, but don't forget to talk about paper. I've seen too many times where that's overlooked. Most people still have some paper. Don't forget about that as well.
All right, let's talk about the meet and confer, the initial meet and confer on preservation of electronic discovery or electronically stored information. What are your goals going into it? What should you know about your own client's information? What do you want to find out from the other side? What agreements do you want to walk away with? What agreements do you want to avoid? Talk to me about the meet and confer. Somebody? Anybody?
I'll start. So from my point of view, my goal is to have told my lawyers, here's the data we can easily retain, it's easy to do, it's not very costly. Here's the data that's hard to do and I don't think relevant. I want to get an agreement that we don't have to preserve these and limit that. And then I also would want to convey the cost of just like how narrow or how broad it would be to like expand it, so that when they go in, I hope they can get an agreement on the issues I don't want to have preserved, and also how much we do have to preserve, just like very specific guidelines, so I can pass that on to the business and say, here's what we do have to preserve, here's what we don't have to preserve. So going forward, it's not like a constant, like, can we do this or not do this?
Anything else to add?
I think that this just depends so much on your opposing counsel. I mean, sometimes you're in a position where you can have those sort of reasonable, rational conversations with opposing counsel, and you can reach a reasonable, rational agreement. And I think that there's more and more support for you to be a proponent of that. And there are some times when opposing counsel might make that unrealistic. So I think your meet and confer is often dictated by, your ability to reach across the aisle and form a sort of working relationship with opposing counsel.
However, if you have that, and maybe that's one of the things that's gradually changing, so for the younger people in the room, if you have that essence of collaboration, the meet and confer can be extremely important to be efficient and to organize documents and to keep costs down and to set the rules. I mean, it's critical if you have, it takes two people to want to collaborate.
A lot of it depends on the case, and particularly if you're talking about clients with symmetrical data issues, preservation issues, collection issues, you may much more easily be able to arrive at a reasonable plan. But often where you've got, one side has all the data, one side's going to have all the burden, one side's going to have all the cost. That's where it can be often difficult to arrive at an agreement, where you may have to have these issues teed up early with the court.
Mark, it's obvious that discovery is a complex project. Lawyers don't usually think of project management as part of their job, but that's largely what a discovery project entails. So not involving anyone in this room, can you give us any examples of where project management has kind of fallen apart? Where are the danger points in project management that you've seen failures happen?
Yeah, it goes back to the planning and the strategy piece, and then kind of the role of the provider, like how aggressive do you insert yourself in the situation? I mean, so what we and other good companies try to do is to bring up options and with some direction on those options. So from the beginning, you can tell if you're working with people that don't have a lot of experience or are not organized or want to start with everything because that's safe. And so then it's up to someone that has to force the issue of getting a kind of a clear path of how we're going to do things and what we're trying to achieve, and the people that are involved in the case that are the most e-discovery savvy, whether it's the attorney, sometimes it's inside the corporation now, or if it's a provider like myself, to really kind of more insert yourself and come up with options and suggestions and keep things obviously positive and professional, but you have to somewhat forcefully insert yourself because everybody wants a good result. They want efficiency, they want cost savings, and you can't do that if you're starting and it's a mess.
And Jeff, from the outside partner perspective, how do you manage the project and the expectations of the client?
Managing the expectations of the client, I think starts at the very outset of the case, and I want, so going and working with a client that I haven't worked with before, I want to come out of the first phone call, a couple of phone calls or meetings with the client, first off, just having confidence that I understand the issues involved in discovery, that I've thought through what their options are, that I've got a plan, reflects that thought, and that I've got recommendations that they, as Chris was saying, may or may not agree with or accept. But I think that's the starting point for everything you're going to do in the discovery process and setting and managing expectations. I think in terms of then actually the expectations themselves, I try at the outset of a case to make sure that I give the client as realistic a budget as I can based on what we know. And a lot of times at the very outset, you don't know. There's a lot you don't know. So it's a process that evolves as the case goes along. But I think starting with a realistic budget, both in terms of hard costs and soft costs, things like disruption to the business and the help that you're going to need from IT and others at the company, monitoring progress and keeping, truing up that budget as you go along, not a set it and forget it. And the one of the things that I found is that clients absolutely hate are surprises. And so if turns out that some aspect of the project is running high compared to an estimate, I want to know as soon as it starts running high so that I can give the client a heads up and let them know why. I found that clients are generally pretty reasonable if something runs high for a good reason. What they hate is to find out a month or 2 months down the line in a bill that something's run $100,000 over, and what the hell?
Chris, how do you keep Jeff in line? He's already gone over budget by $100,000 and we haven't even started.
Not too bad. I really like some things Jeff said, that the realistic budget and then truing up the budget. If giving us a realistic expectation, lets finance know, and then as long as we get updates from our council saying, okay, we're on budget, we're off budget, here's what's going on, we don't get too upset. The worst thing is when we have a relationship with a provider who's helping out in the e-discovery, or there's a third party involved, and maybe our council's managing that relationship, and they're not being very cost effective, and their council's not checking up on it, or there's some doc reviewers that aren't doing a good job and it's just raising things up. Like, it's when council stops ignoring the cost and just is running the case and just running and the bills are getting higher, that's when we get a little alarmed, because we don't like paying those bills. So if you, as council, if you turn off your billable hour hat and go focus on, okay, we're working on this case, are we doing it efficiently? Are we meeting the budget? Can we cut back any costs? Is this discovery proceeding as we expected? If you're doing that kind of analysis, and Jeff clearly was, because he's coming back to true up and point out surprises, then things, I don't have to keep Jeff in line because he's doing it. It's when people aren't doing those things, when they're not coming back and looking at and analyzing their own processes. And that goes from companies like Mark's, if they're going to have relationships with the client as well, and we hope that they do the same thing to us and they come back and manage it and say, oh, here's some expectations, or here's how things are changing, here's how we can do better, and if we change this, you'll save $40,000 over the next few months because the case is slow. We'll archive everything, put the collection on hold. So there's just things council can do and providers can do to us to point out ways we can save money, and if you're doing those things, we'll be happy.
In situations where we're working more directly with the corporation, because they're kind of more of like a serial client and a litigation client, there's more discussions the last year or so around, things that you can't budget for, but budgeting and transparency, alternate fee arrangements, not, different arrangements than like a volume gigabyte arrangement. It's, even though you can't really predict things, they want different models. They want models that some risk on both sides and be able to give an idea of what things will be, and then a lot of communication, and when things change, talk about what those things are. So different than where before everything was more volume gigabyte based, and now it's more engagement based, are the discussions.
Tiffany, you have to deal with Jeff and Chris, and you got to manage Mark, and then you've got associates working with you, you've got paralegals, you've got a contract review team. How do you manage this project?
I think the key is to figure out your own organizational tools. I mean, this is just something generally in your practice that you'll develop over time. I keep a lot of lists. But also, when you're proactive, I think just a couple very common sense guiding principles when you are, managing a meeting, whether it be with the partner or with a contract attorney or be respectful of people's time. So know what you want to be accomplished in that meeting. Have a list of things you want to talk about. If it's a big meeting, I actually find written agendas are very helpful. I mean, you're billing for your time too. You want to be as kind of organized and efficient as possible. And I think the more that you it's also an opportunity for you to kind of demonstrate those skills generally, which I think bodes well for you if they see you, Tiffany is kind of an organized person who stays on top of things. That's also just good for you generally in your reputation and your organization. And the other thing I would say is to be very respectful of other people's times in terms of, deeming things an emergency. Like the practice of litigation is tough enough, and there are enough kind of legitimate overnight emergencies that'll happen. Don't make some up. So you want to build a rapport with the people that you're working with. If you have a vendor that's working for you, don't make that vendor stay up overnight to get you something the next day if you don't need it the next day and you're not going to look at it the next day. It's the most, but I don't know, I think people generate these emergencies that don't exist. Believe me, there will be enough real emergencies, and you don't want to lose all that capital when you don't have to. And actually, the same is true, again, going back to kind of the meet and confer and opposing counsel, it is very helpful to build a relationship with opposing counsel. When they ask for an extension, you're going to need an extension in the future. To the extent that you can work out a good working relationship, I generally find that makes things run smoother and makes everyone's lives kind of happier. I mean, the more you keep everyone in the group informed and everyone knows what they're supposed to do and when it needs to be done, then they can kind of budget efficiently, but, be organized and be respectful of other people's time.
Yeah, well, I think we have to leave it there. That's our time. So thank you, everyone, for coming.